Unfortunately, the legal system has often played a pivotal role in perpetuating historical wrongs against marginalized social groups. Dr. Ambedkar himself highlighted how the policies of the Peshwa regime discriminated against oppressed castes in the annihilation of caste. If you ask me, he said, my ideal would be a society based on liberty, equality, and fraternity. Later, Dr. Ambedkar brought these values in the language of the Constitution itself. And to him, freedom would lack the core of its soul unless freedom came with social freedom. Thank you very much, Raj, for that very warm welcome and introduction. Professor Gordon Simon, Professor Sukhdev Thorat, members of the faculty of Brandeis University and other universities, members of the library, the staff, the participants in the conference, members of the audience, ladies and gentlemen. When Professor Simon and Professor Thorat came to the Supreme Court of India to invite me to deliver the keynote address for the 6th International Conference on the Unfinished Legacy of Dr. B.R. Ambedkar, I was curious to know what this conference was all about. What was the idea behind its inception? And how did a university in the United States get involved in organizing an annual academic conference dedicated to Dr. Babasaheb Ambedkar, popularly known as the chief architect of the Indian Constitution and an inspiration to millions of people in India and around the world? Professor Simon and Professor Thorat passionately told me that the conference was instituted in 2015 and that there have been 5 editions of the conference prior to the one which we are attending right now. And one of the main objectives of the conference is to address issues around caste. I was told that Brandeis University, named after Justice Louis Brandeis, is committed to social justice and, in furtherance of its goals, has been at the helm of running a couple of initiatives focusing on social inequalities in South Asia. Apart from this conference, the Center for Global Development and Sustainability of the university, headed by Professor Simon in collaboration with Professor Thorat in India, also runs an academic journal titled Caste, a global journal on social exclusion. And it organizes the Bluestone Rising Scholar Award for promoting research in areas related to social inequalities. I'm here as much in terms of my own personal tribute to Dr. Babasaheb Ambedkar, whose life, whose work, whose vision has deeply influenced me as a human being and now as a judge. I also use this occasion to celebrate the award which was conferred on my very distinguished former law clerk, Anurag Bhaskar, who is now working at the Center for Research and Planning in the Supreme Court of India. The theme for this year's edition of the conference is Law, Caste and the Pursuit of Justice. As the theme revolves around law, this may be the reason that I have been invited today to deliver the keynote address at the conference. But I'll follow in the footsteps of Justice Louis Brandeis, who became well known globally for the Brandeis Brief. Because as judges, we have to be increasingly cognizant of social reality and to understand that the law itself does not exist in a vacuum. The law exists because of and has a direct connection with society. And what better way to begin this than by a reference to Dr. Ambedkar himself? I must say that I am delighted to be invited to deliver this keynote, more so as the conference in a way pays a tribute to the legacy of Dr. Ambedkar, whom we all see as a guiding light, as a beacon. I also share a personal connection with Dr. Ambedkar. When my father, late Chief Justice Y Chandrachud, was a young lawyer, he would often go to a cafe close to the Bombay High Court called the Wayside Inn at Kalagoda. He always saw a man sitting there the entire afternoon, writing down his thoughts and making notes. My My father would actually use the word furiously making notes and writing down his thoughts. That man was none other than Baba Sahib Dr. Y Ambedkar, who would spend afternoons between court cases writing his notes for the Constituent Assembly and his thoughts for the ultimate constitution that he was going to be an architect for. My father also appeared against Dr. Ambedkar in a case involving an electricity dispute. The title of my keynote address is Reformation Beyond Representation, the social life of the Constitution in remedying historical wrongs. In my address, I shall largely be referring to the Indian Constitution, but I will make references to the American Constitution where necessary. Before proceeding, I will briefly outline the contours of my address today. I intend to begin by discussing what we understand by historical wrongs. What do we mean by the very concept of historical wrongs? I shall discuss what the role of law was in the era of historical wrongs. I will then speak about how leaders such as Dr. Ambedkar conceptualized an alternative framework of emancipatory constitutionalism to address these historical wrongs. I will discuss how the idea of representation was an essential ingredient of remedying historical wrongs. However, representation is only one way of remedying what was historically wrong. Today I want to look beyond representation. There has been a constitutional discourse on social reformation apart from the idea of representation. I shall discuss how the courts play a crucial role in this regard. At the end, I shall discuss why the discourse on reformation must not be limited to courtrooms and must be considered in the canvas of the larger social discourse on equality. But let me begin with historical wrongs. Throughout history, marginalized social groups have been subjected to horrendous, egregious wrongs, often stemming from prejudice, discrimination, and unequal power dynamics. From the brutal transatlantic slave trade that forcibly uprooted millions of Africans, to the Native American displacement, to the caste inequalities in India affecting millions of backward, though Bahujan castes, to the oppression of indigenous Adivasi communities in India, to the systemic oppression of women, LGBTQI individuals, and other minority communities, the annals of history are stained with instances of profound injustice. These wrongs have caused immeasurable suffering and have left lasting scars on these communities, underscoring the urgent need for societal reflection, reconciliation, and efforts to rectify past injustice in the ongoing quest for a more equitable and inclusive world. What sets apart these wrongs is that they deny the core truth of human equality. Reasonable people, governments and courts can disagree over various aspects of human rights, such as questions of privacy and personal liberty. However, the historical wrongs I discuss deny individuals their right to participate in and reap the benefits of living together in society based on the identity of the individual. Bahujan castes were denied access to public spaces, and slaves were denied their very liberty based on nothing beyond who they were, by the color of their skin. Such wrongs pertain not to what rights people have, but rather who constitutes the demos capable of claiming rights from society. Thus, when I say historical wrongs, it is not just about individual bad actions of a few individuals, but social systems and arrangements of identity-based exclusion that go against the very grain and idea of human equality and what may be considered a just and fair society. Unfortunately, the legal system has often played a pivotal role in perpetuating historical wrongs against marginalized social groups. Like in the United States, slavery was legalized in certain parts of India as well. P. Sanal Mohan, in his book titled Modernity of Slavery, Struggles Against Caste Inequality in Colonial Kerala, highlights experiences of several oppressed castes who were enslaved in the erstwhile Indian princely state of Travancore and in other states. This slavery was only abolished in 1855. But even before that, the laws in ancient and medieval India had sanctions against communities whom we now call as Dalits or the scheduled castes. Dr. Ambedkar himself highlighted how the policies of the Peshwa regime discriminated against oppressed castes in the annihilation of caste. The colonial rule was no better in India. The Colonial Era Criminal Tribes Act of 1871 criminalized indigenous tribes, several castes, and eunuchs by declaring them as born criminals. The British colonial courts, as Mark Gallagher has eloquently traced in his essay called Law and Caste in Modern India, refused to rule in favor of oppressed castes when it came to matters of personal law and religious custom. In the United States, from the codification of discriminatory laws that supported the institution of slavery to the Jim Crow laws enforcing segregation in the American South, to the forced assimilation policies targeting indigenous peoples, the legal framework has frequently been weaponized to systematically oppress and marginalize certain communities. The judgments of the US Supreme Court were aggressive on several instances, including Dred Scott in 1857, Plessy v. Ferguson, which was in 1896, and Korematsu in 1944 during the Second World War. Furthermore, both in the United States and in India, the oppressed communities were denied voting rights for a long period of time. In that way, law as an institution was used to maintain existing power structures and to institutionalize discrimination, leaving a lasting legacy of injustice that continues to shape the lives of these groups and communities. Even when these laws have been eventually overturned or repealed, the legacy of their harms can persist for generations, underscoring the complex and enduring relationship between law and historical wrongs committed against marginalized groups. These historical wrongs perpetuate injustice by creating a social system where the marginalized communities are not allowed to rise above their oppression. It creates a kind of self-perpetuating and hierarchical structure of society, which leads to the normalization of injustice towards certain groups. This normalization can creep up to the instances where the alienation of these communities makes them the other in society. Otherness can then create a rift of violence and exclusion of these communities as well. For instance, historical marginalization leads to exclusion in accumulating resources or capital that ought to be equally distributed in society. This exclusion leads to difficulties in overcoming marginalization, even if there has been a recognition of historical wrongs. Consequently, it becomes imperative for the institutional setup of constitutional democracies to make sure that safeguards to these communities are upheld and policies are made for the upliftment of these communities. Recognizing these historical injustices underscores the crucial role of legal reform and the need for a just and inclusive legal system to address past wrongs and work towards a more equitable society. Let me, the second part of my address, refer to emancipatory constitutionalism. What do we mean by emancipatory constitutionalism? What are its potentials? Remedying historical wrongs ought to be the goal of any constitutional system. This has been emphasized by leaders from the oppressed communities who interpreted constitutionalism from the lens of social change. Indeed, using the British Constitution at the time and contemporary state constitutions as a baseline, Akhil Amar Reid, in his very notable text called America's Constitutional Biography, outlines the methods through which the American Constitution rejected historical bases for wielding power and exercising franchise, such as hereditary titles and property ownership that were the norm at the time. However, the framers of the US Constitution failed to remedy the issue of slavery. This was questioned by Frederick Douglass, American abolitionist and social reformer, in a speech before the Scottish Anti-Slavery Society in Glasgow, Scotland, on 26 March 1860. Douglas outlined his views on the American Constitution and stated, "I deny," he said, "I deny that the Constitution guarantees the right to hold property in man, and believe that the way to abolish slavery in America is to vote such men into power, as well as use their powers for the abolition of slavery." In India, the constitutional imagination of equality was done by Dr. Ambedkar. Dr. Ambedkar envisaged a form of constitutionalism that was deeply rooted in democratic principles, social justice, and the protection of individual rights. His vision for the Indian Constitution was shaped by his commitment to ending the deeply entrenched social injustices and discriminations prevalent in Indian society. In several of his writings, he advanced a transformative constitutionalism that aimed to address the historical injustices and systemic discrimination faced by the marginalized and oppressed communities in India. His vision was rooted in the principles of equality, social justice, and the protection of fundamental rights. In his classic yet undelivered address, which he later published as The Annihilation of Caste in 1936, Dr. Ambedkar stated, "If you ask me," he said, "my ideal would be a society based on liberty, equality, and fraternity." Later, Dr. Ambedkar brought these values in the language of the Constitution itself, from the preamble across the entire canvas of the Indian Constitution. Dr. Ambedkar tried to institutionalize social revolution through law. He believed that a just and inclusive society could be achieved through a robust legal framework that would safeguard the rights and dignity of all citizens, particularly those from historically disadvantaged backgrounds. That is the reason why he held a different approach with the other leaders of Indian independence, who focused on political freedom without addressing social freedoms. For Dr. Ambedkar, political freedom was neither an end in itself nor complete or sufficient in itself. And to him, freedom would lack the core of its soul unless freedom came with social freedom. And he wrote, "Political reform cannot with impunity take precedence over social reform in the sense of the reconstruction of society. The makers of political constitutions must take into account social forces as well." Thus, in Dr. Ambedkar's conceptualization, the idea of a constitution goes beyond its traditional role as a mere set of rules and principles for governance. It extended the Constitution's capacity to liberate and empower marginalized and oppressed groups. The emancipatory idea of the Constitution, which Dr. Ambedkar advanced, sought to address historical injustices, challenge systems of discrimination, and advance the cause of emancipation and equality. Furthermore, Dr. Ambedkar's constitutionalism aimed at creating a robust framework of checks and balances, where the Constitution will serve as a bulwark against potential abuses of state power, ensuring the protection of the rights of all citizens. One of the key aspects of Dr. Ambedkar's constitutionalism was the inclusion of affirmative action measures, known as reservations in India, to uplift historically disadvantaged groups. For several decades, he advocated for incorporation of mandatory affirmative action provisions into the Constitution. Dr. Ambedkar believed that such measures would help rectify historical injustices by providing opportunities and representation to the marginalized. He called mandatory affirmative action a form of separation of power. Today, the non-discrimination and affirmative action are often differentiated by references to a negative and positive form of liberty. Arguments that the state ought to abstain from discriminating are distinguished from a positive command or mandate to uplift individuals who have suffered from historical wrongs. It is also argued that affirmative action is fundamentally contrary to the idea of equality or colorblind equality at the least. You find traces of that rationale not only in India but in the US as well, including in recent times. In countries such as India, where affirmative action is actively pursued, non-discrimination and affirmative action are also differentiated through institutional roles between Parliament and the judiciary. It is argued that it is the court's duty to enforce non-discrimination norms, but mandates for affirmative action are left as questions for elected officials. However, Dr. Ambedkar did not view equality and affirmative action as contradictory. This is because he conceived equality and liberty as intrinsically connected norms. Notions of negative freedom contemplate freedom from interference. However, as Republican scholars have argued for centuries, the idea of freedom as the absence of state restrictions fails to recognize the difference between being free from interference and being free to act. Using the classical Republican example, a slave may never be put in a cage or beaten, but that does not make them free to act. Negative conceptions of freedom characterize liberty as the absence of episodic interference. For after all, interference is inherently temporal. When a person is in prison, they are not free. When they are released, they are free. However, such negative conceptions of freedom ignore the ongoing deprivations that can arise out of dominating relationships or societal arrangements outside of episodic interferences with liberty. An individual may not be imprisoned, but the social, legal, and economic structures that govern their lives lead to domination on the side of caste, race, gender, disability, or economic well-being. I would submit that Dr. Ambedkar took aim at precisely such forms of dominating relations and societal arrangements when he seeks to secure freedom as a means of social transformation. In the annihilation of caste, he characterizes liberty as the destruction of the dominion which one man holds over another. He argued that if the source of power and dominion is at any given point of time or in any given society, social and religious, then social reform and religious reform must be accepted as the necessary sort of reform. That is, even where domination is the result of actions by non-state actors or structural societal arrangements, liberty is at risk and must be remedied through by the state. After all, liberty does not mean liberty to discriminate. By characterizing liberty as relational and not episodic, Dr. Ambedkar conceived of liberty and equality as two sides of the same coin. For him, ensuring liberty required ensuring that every person in a society had sufficient standing that they were not dominated, whether that be through economic, social, or religious power. Unlike narrower conceptions of liberty that seek solely to prevent episodic state intervention, conceiving of freedom as non-domination allows the very sight of state intervention to be liberty-generating by eradicating the sources of dominating power. Thus, Dr. Ambedkar conceived of a reformative movement that was simultaneously interventionist, yet liberty-enhancing. This is not to say that Dr. Ambedkar ignored the risks of excessive state intervention. His vision also encompassed the establishment of an independent judiciary that would serve as a guardian of the Constitution, interpreting and upholding its principles. He famously called Article 32 of the Indian Constitution, which provides the citizens the right to move the Supreme Court, as the heart and the soul of the Constitution. In a sense, his vision for constitutionalism emphasized not only the protection of fundamental rights, but also the active protection and promotion of social equality and justice, making it a cornerstone of modern India's democratic framework. The Indian Constitution in 1950 incorporated a set of fundamental rights such as the right to equality, the right to freedom from discrimination, and the right to equal protection under the law. Apart from affirmative action, the most important impact of Dr. Ambedkar's formulation was Article 17, which abolishes untouchability and was placed in the chapter on fundamental rights, along with the provisions of equality and non-discrimination. It was hoped that these provisions would break the shackles of caste-based discrimination and untouchability, fostering a more equitable and harmonious society. After its adoption, the Indian Constitution has interacted with the society in different ways. I have used Article 17 and the West against untouchability, and I've extrapolated it in the context of laws or customs which excluded women of menstruating age from worship in temples. In the third part of my address this afternoon, let me focus on the impact of the Indian Constitution. The social life of a constitution refers to how a constitution functions within a society, its impact on the daily lives of citizens, how citizens perceive it, and its adaptability to changing social, political, and cultural dynamics. The phrase social life recognizes that a constitution is not just a static legal document, but a living framework that interacts with and shapes the social and political environment in which it operates. In a sense, the social life of a constitution is about how the constitution functions within the broader context of society, impacting not only the legal and political spheres, but also the cultural and economic and other social aspects of the lives of our citizens. It reflects the dynamic and evolving nature of constitutional governance as it responds to the needs and values of the people it serves. The adoption of the Constitution, the Indian Constitution, was seen as a moment of a tectonic shift in Indian history. American historian Brandeis traveled to India to document the process of drafting India's constitution. In his classic book, The Indian Constitution, Cornerstone of a Nation, Austin termed the Indian Constitution a social revolutionary statement by its very existence, he said, a modernizing force. Austin narrated, and I quote him, "Representative government with adult suffrage, a Bill of Rights providing for equality under law and personal liberty, and an independent judiciary were to become the spiritual and institutional basis for a new society, one replacing the traditional hierarchy and its repressions. Other constitutional provisions were designed to spread democracy by protecting and increasing the rights of minorities, by assisting underprivileged groups in society to better their condition, and by ending the blatant oppression of the scheduled castes and tribes. These provisions have brought into, or closer to, the mainstream of society individuals and groups that would otherwise have remained at society's bottom or its edges. In that sense, the Constitution attempted to replace fundamental wrongs with fundamental rights. Affirmative action and representation were a crucial component of constitutional foundations laid down in India. As mentioned earlier, Dr. Ambedkar fought tooth and nail to get the provisions of affirmative action incorporated into the Indian Constitution. It was Dr. Ambedkar's belief that the oppressed should have their own representation, and that representation would develop political conscience among these communities. Dr. Ambedkar stated that the British colonial rule over Indians was morally wrong, then in the same way, the rule of oppressor castes over the oppressed was equally wrong. This again highlights Dr. Ambedkar's idea of freedom as relational. He saw no difference between the actions of a colonial power in jailing political prisoners and the denial of access to public resources by the oppressor castes. What mattered was a dominating relationship between the two individuals concerned. While the British departed in 1947, the dominating effects of caste oppression subsisted. Since independence, affirmative action policies in India have offered crucial support to oppressed social groups by providing them with opportunities for education, employment, and representation that might otherwise be inaccessible due to deeply entrenched inequalities. As noted in the judgment of the Supreme Court of India in Indira Sahni versus Union of India in 1992, the objective was to change the social face as it shall advance public welfare by demolishing rigidity of caste, promoting representation of those who till now were kept away, thus providing status to them, restoring balance in society, reducing poverty, and increasing the distribution of benefits and advantages to one and all. In theory as well as in practice, these policies serve as a means to level the playing field, granting access to opportunities that may have been systematically denied in the past. By actively including underrepresented individuals in education and employment sectors, affirmative action helps bring down barriers. It develops a psychological assurance that individuals from marginalized backgrounds have a shot at achieving their full potential and contributing to the collective well-being of the community. Looking at the statistics, the representation of constitutionally protected social groups for the scheduled castes and the scheduled tribes has increased in the government services under various categories over the last 7 decades. At the dawn of independence, representation of the scheduled castes and scheduled tribes in services was marginal. According to available information, as on 1 January 1965, the representation of the scheduled castes in the Group A of government services, which are the top-level bureaucratic posts, was just 1.64%, which increased to 13.21% as on 1 January 2022. Likewise, the representation of the scheduled tribes as on 1 January 1965 in the Group A post was 0.27%. It has increased to 6.01% as on 1 January 2022. This is the direct impact of the Constitution. The presence of marginalized communities in services, education, and in political representation is in itself a realization of our constitutional mandate. This is how the social presence of the oppressed communities demonstrates the success of the social life of the Constitution in a way that is being implemented. Furthermore, the oppressed communities in India used the vocabulary of the Indian Constitution with a focus on equality and affirmative action to mobilize and reclaim their sense of dignity. The Constitution of India legitimized the obvious personhood of the oppressed communities. But above all, let us remember that Dr. Ambedkar and his vision were responsible for replacing what would have been a culture of violence with a culture grounded in the Constitution and the rule of law. Social transformation therefore became a peaceful transformation, using the instruments of the Constitution to further social change. This was one way to facilitate and empower individuals from marginalized backgrounds to break free from cycles of oppression and help in rectifying historical injustice. Moreover, it has sent a clear message that society is committed to correcting systematic biases and working towards greater equality, ultimately fostering a more just and inclusive environment for all. Let me next dwell in the next segment on the limits around affirmative action. The mere presence of the members of oppressed groups in government services must not be seen as the only parameter to analyze the power structures of society. Let's take the example of a press release which stated, and I quote, "The representation of the scheduled castes and scheduled tribes in the posts and services under the central government as on 1 January 2016 was 17.49% and 8.47% respectively. Representation of the SCs and STs is more than the prescribed percentage of reservation, 15% and 7%. That's the press note which I have quoted. However, this press release does not mention how many scheduled castes are in top decision-making positions in government and how many in the lowest level positions. The real question, therefore, is what the representation of the scheduled castes and scheduled tribes in top positions is. The statistics show that out of a total of 322 officers currently holding the posts of joint secretaries and secretaries, which are top-level bureaucratic posts in our civil service, in different ministries and departments under the Government of India, only 16 belong to scheduled castes, which is 4.9% of the total posts, and only 13 belong to scheduled tribes, which is only 4%. These statistics, in other words, show that focusing only on the total number of employees rather than examining how many scheduled castes and tribes hold top positions is misleading. Reformation beyond representation entails ensuring that marginalized and underrepresented communities not only have a seat at the table, but that they have a meaningful voice in decision-making processes. There is also concern that in spaces where representation is not legally mandated, representation must not be confused with diversity. It has been stated by scholars that the sole focus on diversity can lead to tokenism, where individuals from underrepresented groups are viewed as symbols of diversity rather than being valued for their skills and their qualifications. This can undermine their professional and personal growth. Ellen Berry, through his book titled The Enigma of Diversity, The Language of Race and the Limits of Racial Justice of 2015, has struck a chord of caution that the invocation of diversity must not be reduced to tokenism. She argues, diversity advocates efforts to minimize group divisions and expand the bounds of social membership have focused on symbolism more than on social causes. Much discourse on diversity leaves advocates without a language for talking about inequality. Diversity, therefore, needs to be understood from the perspective of representation and social discrimination. Institutions need to be more diverse because communities that have been subjected to historical discrimination are underrepresented. Thus, as in India, historical wrongs form an independent justification for affirmative action, irrespective of concerns of promoting diversity. The idea of representation through affirmative action must be facilitated by discourse on broader systemic issues, such as unequal access to quality education for everyone. Affirmative action in itself cannot solve the issue of universal education. Rather, it is connected to universal education. When a greater number of people from oppressed groups would gain education, their presence in institutions through affirmative action will increase. That is when the full potential of affirmative action will be seen. Thus, social reformation involves dismantling systemic barriers and addressing structural inequality. This will encompass reforms in education, healthcare, criminal justice, and economic systems that have historically disadvantaged certain groups. Even the slightest success of affirmative action is used by caste elites to dismiss the issues around caste inequalities. Arguments are advanced that just because affirmative action is being provided, structural issues of discrimination don't exist anymore at all. Such binary narrations must be rejected, and I believe rejected at the constitutional level.